So let's come down to the issue of arbitrability of fraud and examine its contours so as to assess what exactly is arbitrability of fraud and how has it been interpreted by our courts in general. So let's begin with examining the interpretation or the usage of the phrase arbitrability. The expression arbitrability, you'd be surprised, is not found in the Arbitration and Conciliation Act of 1996. It was first used by Justice Ravindran in Booz Allen's case, which is a 2011 Supreme Court decision. In this decision, he laid down a triple test for arbitrability. On this triple test, he said that there are three paradigms or three features which need to be fulfilled for an issue to be considered arbitrable. He said first, this must be something which is capable of being resolved via arbitration. Second, it should be something which is covered by the arbitration agreement and the arbitration clause. And lastly, it should be something which is being referred itself to arbitration. So that was the triple test which he had in mind. Now, if we look at this triple test and then have a broad classification in mind so as to understand what is it that is arbitrable and what is it that is not arbitrable. A rule of thumb can be that rights in rem, which are rights which you can claim against the whole world at large, they are incapable of being arbitrated and they are inarbitrable or non-arbitrable. The second category is rights in personam. These are rights which you can seek against one particular individual, and these rights are capable of being resolved and adjudicated via arbitration. So a classic example of something which would be considered to be non-arbitrable would be, say, a criminal law dispute or a child custody matter or an insolvency related dispute. These are certain issues which are not capable of being resolved via arbitration. And any reference to arbitration here would fail in that regard. Now, another feature which emerges from this is that what Justice Ravindran held in the in the Booz Allen dispute was that all these cases or all these issues in question are fluid in nature. And given that they are fluid in nature, it is something which can be either expanded upon by the courts in question, or it can be something which can be shrunk by the courts in question. So I'm not going to go over the decisions in detail, but there are a few of them which deal with this subject at hand. So there are 5 of them in particular. The first is Vimal Kishore Shah. The second is MRMGF on the review petition. The third is Himangi Enterprises. The fourth is Nataraj Studios. And the fifth is Vidya Drolia. So these are sort of 5 cases in which the Supreme Court has had occasion to either interpret this in question in terms of expanding it or shrinking it. So that is broadly what is here in question. Let's now come to understand as to what is its historical perspective and how has it evolved historically. Because to understand the present and the future, it's very important to understand as to what has been the legislative underpinning and how is it that this has come into picture. So the present Arbitration and Conciliation Act came in 1996. There were 2 predecessor enactments. The first one was the Indian Arbitration Act of 1899. And the second one was the Arbitration and Conciliation Act of 1940. However, the issue of arbitrability of fraud, in fact, predates both these enactments. And this came about in the 19th century by a British court decision of Russell versus Russell, which was delivered in 1880. Russell versus Russell has been the theoretical foundation for arbitrability of fraud. And that is where this evolution can really be traced from. So Russell versus Russell in 1880, the English courts or the British courts at that time, they introduced a prima facie test. As per this prima facie test, they held that courts and judicial forums may refuse a reference to arbitration if there exists sufficient prima facie evidence to support the existence of fraud. So in this case, the understanding or the logic and the rationale became that if there is an issue of fraud, then an arbitral tribunal may not necessarily be the most equipped and the most robust form of dispute resolution to adjudicate on the matter. You may require a civil court to hear this matter, to decide this matter. It was on the idea that a civil court is better suited to do it. It is public in nature. The hearings are available for being viewed by the public at large. And given that fraud allegations destroy a person's reputation in some manner, that person has the ability or has the chance to get his name cleared through a public forum as opposed to a confidential mechanism which is available in the arbitration setup. So that was the basic logic and rationale of the Russell versus Russell decision of 1880. Now, if we move a little ahead of Russell versus Russell and come to the Indian situation or the British Indian situation at that point in time, let's try and understand as to how it emerged during that particular point in time. So India had its first Arbitration Act of 1899. Now this Indian Arbitration Act of 1899 in British India or pre-independent India at that point in time said that this act will have application to the presidency towns in India. So the presidency towns in India were made to follow this act, and its territorial jurisdiction extended to those. So in pre-independent India, there are three decisions which are extremely relevant so as to understand how arbitrability of fraud has really evolved in this regard. These three decisions are that of the Madras High Court, of the Patna High Court, and of the Bombay High Court. So let's begin with the Madras High Court and then come to Patna High Court and then at last look at the Bombay High Court. All these decisions either follow Russell versus Russell or they depart from Russell versus Russell. So let's see how it has emerged in that regard. Madras High Court in 1938 in Laldas Lakshmi case followed Russell versus Russell. It said that this is a situation wherein if you have something which is indicative or presents a prima facie establishment or indication of fraud, then arbitration will not be allowed in this regard. That was the Madras High Court in 1938. The Patna High Court in 1943 also chose to follow the same course of action. It said that this is a situation wherein there is prima facie evidence to indicate that fraud has been perpetrated, and therefore we will have no reference to arbitration in this regard because civil courts are better suited to resolve this dispute in question. And the last decision which we are discussing today in pre-independent India is that of the Bombay High Court, which is in 1929, Raniganj Coal Association. Now, Raniganj Coal Association's decision by the Bombay High Court is a marked departure from the Russell versus Russell paradigm. Now, you would recollect that Russell versus Russell said that a reference to arbitration will be refused if there exists prima facie evidence to support the existence of fraud. Raniganj Coal Association took a slightly different view and it deviated from Russell versus Russell. It said that mere allegations of fraud without any kind of details would not result in a refusal of reference to arbitration. This was a very progressive decision and well ahead of its time at that particular point in time in 1929, because it indicated that judicial forums and constitutional courts, or for that matter charter courts, were displaying a certain amount of trust and a certain amount of faith in private adjudicatory forums such as arbitration. But there was no great distrust in it. It wasn't as if that merely because it's a private forum, it will be incapable of resolving this particular issue. So that decision of the Bombay High Court in 1929 was well ahead of its time, but however, it did not really materialize into something extremely fruitful at that point in time. So I'll just repeat the three decisions in question. The Madras High Court decision was Laldas Lakshmi, which came of 1938. It followed Russell versus Russell. Patna High Court was Narsingh Prasad Bubna of 1943, which again followed Russell versus Russell. And Bombay High Court was of 1929 in Raniganj Coal Association, which deviated from Russell versus Russell. So that was the story of pre-independent India or British India. Now let's come to independent India. And just before that, in 1940, or a little before that, as opposed to just before that, in 1940, India had its own separate legislation in this regard, which was the Arbitration Act of 1940. This replaced the 1899 Act. So a few decisions which emerged then in independent India came through the 1940 Act. The first time when the Indian Supreme Court had occasion to deal with arbitrability of fraud in independent India came in 1962. This is the Abdul Qadir case. Now the Abdul Qadir case is something which again emerged from the Bombay High Court, and before that the trial courts in Bombay. The trial courts declined a reference to arbitration by holding that there are allegations of fraud in the particular dispute, and they nullify any reference to arbitration, and they completely extinguish the possibility of the matter being resolved via arbitration. The matter was carried forward in appeal for the Bombay High Court. The Bombay High Court reversed the trial court by holding that, one, these allegations were not of fraud, and two, it said that even if they were of fraud, then they were not of such a nature which would deprive a reference or disentitle a reference to arbitration. This matter then went further up in appeal to the Supreme Court. Now the Supreme Court here came up and it laid great emphasis on the idea of seriousness of fraud. And it said that the fraud here was not serious enough to warrant interference with arbitration proceedings. So it said that even if there is fraud, which we can theoretically or for the purposes of argument accept that there is in the particular case, it is not of such a serious nature that it will disentitle any reference to arbitration, and we will not interfere with arbitral proceedings just on this ground. So that is the independent India's first opportunity of dealing with the issue of arbitrability of fraud. And this was of 1962. We are almost 60 years forward. But in some manner, the seriousness of fraud issue still continues to survive in the present situation. So let's now come to the new Arbitration Act, which came about in 1996. Now, the new Arbitration Act of 1996 was necessitated by two significant features or two significant developments. The first significant development was that India had achieved economic liberalization, or India had undergone economic liberalization in 1991. So from being a predominantly socialist country in its approach, India was now also seeking to experiment with capitalism in a great manner. And the other development was more international in nature, was that the UNCITRAL had come out with a model law in 1985. So these two developments necessarily made sure that if India did not change its arbitration legislation, it would be at a very, very disadvantageous position, and it can never sort of seek to attract new business, because we all know that the pace of judicial proceedings in India is ridiculously slow. So all kinds of new businesses which were seeking to come into India from foreign jurisdictions started putting a certain amount of pressure on the Indian government, and the Indian government also realized it on their own that if they do not evolve their arbitration legislation, then you can never really offer any kind of surety to the investors and to the new businesses that their disputes would be resolved within a specific time frame, as opposed to being dragged on continuously in the Indian judicial forums. So these were two situations which resulted, or two developments which resulted in the enactment of the 1996 legislation. Now, in the 1996 legislation, which is the current legislation governing the issue, there are four big decisions which we have to deal with, and they've all come in the past few years. So it's quite convenient to trace their trajectory. These four decisions are N. Radhakrishnan of 2009 by the Supreme Court, Swiss Timing 2014 by the Supreme Court, Ayyasami, which is 2016 by the Supreme Court, and Rashid Raza, which is 2019 by the Supreme Court. So I'll just repeat the name of the decisions: Radhakrishnan, Swiss Timing, Ayyasami, and Rashid Raza. Radhakrishnan was a decision which came about in 2009 of the Supreme Court. It was a Section 8 dispute. Now, Section 8 of the Arbitration and Conciliation Act says that if a party has an objection to a civil suit, then it can seek a compulsory reference to arbitration if the agreement between the parties provides for an arbitration clause. And the courts will be duty bound to refer this matter to arbitration, provided that the party which is seeking to oppose the civil suit, which is the defendant, is presenting this objection at a stage which is not later than the filing of the written statement. So it does a few things. One, it places the onus of seeking reference to arbitration on the person who is seeking to oppose the existence of the civil suit, because it doesn't want to prejudice a party which has come to court from not having its matter resolved at all. And second, what it does is that if the party which is defending the civil suit or which is resisting the civil suit does not take this objection at the time of filing the written statement, or it does not raise it before the filing of the written statement, then it waives this objection in toto. So these are two important features which we must remember when dealing with Section 8. So Radhakrishnan was a Section 8 decision, or a Section 8 dispute which resulted in a decision. In this, the courts refused a reference to arbitration and held that the allegations of fraud were fairly serious or were extremely serious. So in doing so, it effectively followed Abdul Qadir of 1962, and it said that the seriousness of fraud allegations are such that a reference to arbitration would not be the best mode to resolve the dispute, and it should not be the situation which is followed. Now, the problem with this decision was that it followed Abdul Qadir without realizing that there is a new legislation in question. The new legislation had indicated a departure from the old legislation, because in this Section 8 had been introduced. So while dealing with it under Section 8, the court still chose, or the Supreme Court still chose to follow the Abdul Qadir logic, and it declined this reference to arbitration. So this marked a setback to the arbitration mechanism in India, because it indicated that courts will be interfering with the commercial dispute resolution process and not even referring the matters to arbitration. So it indicated a great setback to the arbitration landscape in India. And this was a decision which was delivered in 2009 by two judges of the Supreme Court. We next moved to 2014 and the decision of Swiss timing. 2014 Swiss timing was a dispute which came about under Section 11 of the Arbitration and Conciliation Act. Now, Section 11 of the Arbitration and Conciliation Act applies both to international arbitrations as well as to domestic arbitration. That's one. And second, the essence of Section 11 is that if parties in question are unable to mutually agree upon the appointment of an arbitrator, then the courts, the High Court in the case of domestic commercial arbitrations and the Supreme Court in the case of international commercial arbitrations, will be equipped and will be duty bound to appoint an arbitrator to resolve the dispute in question. So this is the basic understanding of Section 11. And in this backdrop, let's come down to analyze as to what Swiss timing really did. Swiss timing came about due to the Commonwealth Games fiasco, which was held in Delhi in 2008. Now, in the Commonwealth Games, there were large-scale allegations of fraud, of commercial misdealing, of criminal misappropriation of funds, etc., etc. And that had a spillover effect in this regard, because the Commonwealth Games Organizing Committee got into a dispute with a company that was providing equipment. And the defense which was taken when the matter was sought to be referred to arbitration was that there are serious allegations of fraud in question here. So arbitration is not the most appropriate mechanism to resolve the dispute in question. The court said nothing doing, please forget it. The lodging of a criminal case would not frustrate the arbitration clause, and it would not defeat the existence or the continuation and initiation of arbitration proceedings. So that was an extremely progressive decision in that regard. And its progressive nature can be gauged by two features. One, it effectively held that criminal proceedings are not a trump card for defeating arbitrations. And second, it reaffirmed the competence principle encapsulated in Section 16 of the present Arbitration and Conciliation Act, which says that an arbitral tribunal is perfectly capable of deciding on its own jurisdiction. So these were the progressive features of the arbitration decision delivered by the Swiss timing decision. What was problematic, however, was one feature of it. Swiss timing was a decision delivered by a single judge of the Supreme Court, Justice Nijjar. And Justice Nijjar, in a single bench composition, held that N. Radhakrishnan of 2009 was a per incurium decision. Per incurium basically means without regard to law. And it effectively sought to overrule N. Radhakrishnan. Now the problem became that a single judge cannot hold a division bench or a two-judge bench decision to be per incurium. And that is the defect and that is the flaw in the present situation which emerged. So Swiss timing to that regard was extremely problematic. However, we'll come back to Swiss timing and see as to how it has affected the landscape of arbitrability of fraud. The next decision which came about was in 2016, Ayasami. Ayasami effectively, again a two-judge bench decision, impliedly overruled Swiss timing, because Swiss timing was quite problematic to the extent that it said that if you have a situation wherein a single judge is holding a division bench to be per incurium, then it cannot be good law because it does not follow the hierarchy of judicial precedents. And it's a case of judicial indiscipline, if one were to put it like that. So Ayasami had to impliedly overrule Swiss timing without holding it to be bad law in that regard. So that was the jurisprudential feature of Ayasami. Ayasami was again a decision under Section 8 of the Arbitration and Conciliation Act, same as N. Radhakrishnan. And Ayasami created a dual classification of serious fraud and fraud simpliciter. Serious fraud can also be understood as complex fraud, and fraud simpliciter can also be understood as elementary fraud or simple fraud or basic fraud. So it said that if something is serious in nature, we will not have arbitration as the mode and mechanism to resolve the dispute. However, if something is simple in nature, or the fraud is simple, basic, elementary in nature, then we can have it resolved through arbitration. So what it did was that it effectively said if there is something which is affecting only the internal affairs of the party and overall there is no great overlap and spillover to the public domain, then it is something which we can let arbitral tribunals adjudicate on, and we can let arbitral tribunals decide on the correctness of this. So while doing so, it appointed an arbitrator and it directed the parties to have their dispute resolved by arbitration. Ayasami in 2016 was again a two-judge bench decision, Justice Sikri and Justice D.Y. Chandrachud. Now, let's come down to the latest decision on point, which is Rashid Raza. Rashid Raza in 2019, September, was a decision which was delivered by 3 judges. Justice Nariman authored the decision. There were 2 other judges on the panel or on the bench, which were Justice Reddy and Justice Suryakant. That was the composition of the bench in question. Rashid Raza was a Section 11 dispute which had come from the Jharkhand High Court, and the Jharkhand High Court effectively misunderstood the ratio of Ayasami. Ayasami's ratio is contained in para 25. Jharkhand High Court reproduced para 26 of the decision. So it was an error by the Jharkhand High Court which led this matter to come here. Jharkhand High Court said that this dispute between 2 parties who are partners in a partnership firm is so complex due to the lodging of an FIR that we will not deal with this matter, and this is a matter which can only be resolved by a court and not by arbitral forums. So it declined the reference to arbitration under Section 11. The matter went up in SLP and went up in appeal to the Supreme Court. Now, in this particular situation, the Supreme Court effectively decided as to what were the parameters to determine serious fraud and what would be the parameters to determine what would be basic fraud. So the Supreme Court in this decision set aside the verdict of the Jharkhand High Court, and it said that we accept that this is a situation of fraud and this is a situation wherein wherein we have a case of a partnership firm being beset by allegations and counter allegations of fraudulent misdealings. But we will have a situation which can only be resolved through the arbitration setup in this particular regard. So that is what the Supreme Court did in this particular situation. The Supreme Court in this particular case said that this is not a case of serious fraud. And because this is not a case of serious fraud, we will have a reference to arbitration, and the arbitrator will decide as to what is the correctness of the allegations in question and what is the weight which can be assigned to these allegations. It said that as a judicial forum, it is not going to get into this dispute at all. And while delivering this decision on what constitutes serious fraud, it said that there are two features. The first is that the plea of fraud should permeate the full contract and the arbitration agreement to render it null and void. That is the first situation. The second situation would be that if the fraud allegations only relate to the internal affairs of the parties in question and do not have a spillover impact on the public domain, then this would be a situation which is basic fraud in nature and not complex fraud and not serious fraud. So it said that as long as the public at large is not being affected by allegations of fraud between the two disputing parties, it would not be a situation wherein we will have parties being influenced by it, and the matters are perfectly capable of being resolved via arbitration in this particular regard. So one important feature of the Rashid Raza decision was that the Supreme Court was subconsciously affected by section 11 subsection 6A. This is a section which existed at the time and now has been repealed. This particular section said that if there is an arbitration clause in the agreement between the parties, then the court must appoint an arbitrator. It should only see whether there is an arbitration clause, and if there is an arbitration clause, then it is duty bound to refer the matter to arbitration. So that was the subconscious impact of section 11 in this particular regard. Subsection 11(6)(a) rather, if I can re-emphasize on that point. So in that particular regard, it said that this is the situation wherein we will adjudicate a matter via arbitration. And now what Rashid Raza has effectively done is that by being a 3-judge bench decision, it has effectively affirmed and explained Ayyasami. So Ayyasami, for whatever little problems that it has, is now, by virtue of Rashid Raza being a decision of 3 judges, is the binding law on the point, courtesy Rashid Raza. And these now lead to a few situations which indicate as to what is the problem in question with the present setup and how can we remedy these problems in question. The present problems wherein we have this dual classification of fraud and simple fraud, or complex fraud and simple fraud, emerges from the fact that there is an inherent mistrust on the arbitral tribunal being capable of resolving these disputes on their own accord or through their own mechanism. Now, there is a feeling that arbitral tribunals, being private forums in nature, do not have the necessary paraphernalia or the necessary apparatus in this particular situation to adjudicate all these disputes on their own. This ignores two legislative features. One, it ignores Section 16 of the Arbitration and Conciliation Act, which is the competence principle, and holds that an arbitral tribunal is perfectly capable of resolving these issues through their own selves. Once you raise a dispute about jurisdiction to the arbitral tribunal, it is capable of resolving it through its own self. By courts declining references to arbitration, they are effectively undertaking a pre-reference adjudication on merits, and they are nullifying Section 16 of the Arbitration and Conciliation Act and diluting the competence principle. That is the first basic problem which exists in this regard. The second problem which exists in this regard is that it ignores the developments which have taken place on an academic level in this matter, wherein the 246th Law Commission report, which dealt with the Arbitration and Conciliation Act, made a specific recommendation that, and it suggested that please amend Section 16 and have all frauds to be mandatorily arbitrable. That is something which is not being done in Section 16 at the moment. And what was quite, and I'll come back to Ayyasamy at this point in time, Ayyasamy refers to the Law Commission report, the 246th Law Commission report in this regard, but it does not notice this para of the Law Commission report. It notices the immediately preceding para and declines to deliver a decision on this point. If Ayyasamy had just gone a step further and said that fraud, irrespective of its seriousness or basic elementary nature, can be resolved by arbitration, a lot of problems would have been solved. The third issue which exists in this particular point in time is that this dual classification of simple fraud and complex fraud leaves everything to judicial discretion. And by leaving everything to judicial discretion, it creates huge problems in question. So a classic set of circumstances which can explain this was that there was a paddy scam in Bihar, a rice scam in Bihar, in which there were about 250 cases which traveled to the Supreme Court for cancellation of bail. The state and the paddy corporation or the food corporation was up in appeal because bail had been granted to a lot of people by the Patna High Court in all these matters, and the courts were adjudicating as to what is the real impact of this scam. So the court in the Devesh Kumar Chaudhary case, a bench of Justice Lalit and Justice Goyal, who's now retired, Justice Goyal, who's now retired, and the NGT chairman, they had occasion to deal with this. They said that, look, this is a scam of 1,500 crores. There are 250 cases which have come before us. We believe that the fraud is of such a nature that we should have 5 special criminal courts, 5 special trial courts, which should hear only these matters and decide them, because there is a large impact on the public at large. So this was round 1 of the litigation. Round 2 of the litigation began again in the Patna High Court, because a lot of people who suffered this decision realized that if they go through with the criminal trial, then there is a possibility of conviction, because there are these special courts, and these special courts at the Supreme Court's command may feel a certain amount of pressure upon them, and they may decide against it. So to safeguard their interests, they started filing Section 11 arbitration applications in the Patna High Court. These Section 11 applications in the Patna High Court came to be decided by the Sadhana Kumari case. The Sadhana Kumari case effectively said that there is an arbitration clause. Section 11(6) capital A says that once there is an arbitration clause, there has to be a compulsory reference or a mandatory reference to arbitration. Let these disputes be resolved via arbitration. So in all these 250 cases, the lead case being Sadhana Kumari, it said that all these cases will be resolved via arbitration. The state and the food corporation were obviously very, very disturbed by it, because there was an indication by the Supreme Court and a decision by the Supreme Court in the Divesh Kumar Chaudhary case, which said that these are such complex frauds that you need special courts. And if you need special courts, then why do you need arbitration? Because Ayyasamy holds that if it is complex fraud, if it is serious fraud, then you must resolve these disputes through arbitration. And if it is complex fraud, you must resolve it through the judicial process, through civil courts, through criminal courts, and not through the arbitral proceedings. So that was what led the state and the food corporation to challenge it in the Supreme Court. The challenge came up before the same bench of Justice Goyal and Justice Lalit. At this particular point in time, Justice Goyal and Justice Lalit said that yes, it may have been complex fraud. The decision is a in limine dismissal. So I'm only narrating the courtroom proceedings. They said that yes, it may have been simple fraud or complex fraud, whatever it may be. To accept it may have been complex fraud because there are in fact 5 forums which we have set up on our own. But the mere fact that criminal proceedings are being conducted will not defeat the existence of or the initiation of arbitral proceedings. So by doing so, it effectively nullified the effect of Ayyasamy without dealing with Ayyasamy. That is one. Second, what it did was that it ideologically aligned itself with the holding of Swiss timing. The holding of Swiss timing was that if there are criminal proceedings, they will not act as a trump card to defeat arbitral proceedings or to defeat arbitration in this regard. So this decision effectively points to us, one, that Swiss timing, despite being impliedly overruled, still remains within the judicial conscience of the judges in question. Two, it also indicates that criminal proceedings can never act as a trump card so as to defeat reference to arbitration. Three, it indicates that there is a greater amount of trust being displayed on the arbitral forums in this regard, and it is being said that arbitral tribunals are perfectly capable of adjudicating these disputes on their own. So those are sort of some features which emerge out of the Sadhana Kumari litigation and the Divesh Kumar Chaudhary litigation, which was heard by the Supreme Court through Justice Lalit and through Justice Goyal. One, it indicates that criminal proceedings will not be a trump card. Two, it indicates that in these particular situations, arbitral tribunals are perfectly capable of adjudicating these disputes through their own. And three, it also delivers a vote of confidence in the arbitral tribunals, so as to say that these can perfectly hear these matters. It also sort of aligns with Justice Lalit's view in arbitration matters, the most important recent decision being the Perkins decision, wherein he is extremely pro-arbitration, and it shows that if there is a dispute which can be resolved via arbitration, then it must be resolved via arbitration, and it should not be that single party is deriving benefit and there is a playing field which is not level in question, which is what he has done in the Perkins case. Because if a party appoints the sole arbitrator and it has the sole prerogative of doing so, Justice Lalit in that decision, along with Justice Indu Malhotra, has said that no, sorry, that will not be permitted. A single party with the sole prerogative cannot appoint the sole arbitrator, because it gives the impression that there is no level playing field. So the Divesh Kumar Chaudhary and the Sadhana Kumari decision also go a little further, and they also support Justice Lalit's general view vis-a-vis arbitration. But coming back to our feature, it indicates as to what is the problem with simple fraud and complex fraud in question. There is no great certainty in this regard. Now, what if we were to pose a question to ourselves? What could be more complex than the fact that the Supreme Court itself appoints 5 special courts to hear the matters? It indicates the seriousness of fraud. It notes the amount of cases before it. It notes the quantum of dispute before it, and then still it holds that no, we will not have this being resolved through the regular process. Arbitration is good enough to do it. There are 1 or 2 more disputes or problems which arise in this particular situation, and I'll go quickly over them. The first is that, or the next rather, is that international arbitrations already include the fact or already allow all fraud to be resolved via arbitration. So international arbitration has all frauds arbitrable, but domestic arbitration does not. The effect of this is that you're effectively encouraging international arbitration and discouraging commercial arbitration in the domestic sphere. So for small disputes, say worth a few lakhs or worth a few crores even, parties may not find it worth their time to seat the arbitration outside India. But if there is an anticipation that a dispute is extremely complex in nature and these kind of objections can be taken before judicial forums, then parties can simply move their arbitrations to outside India by having it as an international commercial arbitration through their arbitration clauses. So that is one particular feature which is again problematic in these decisions. So that is the other issue. The last issue which emerges, or the second last issue which emerges out of this, and I'll just, there's a question, so I'll just re-emphasize this point. International arbitrations through the World Sport Group decisions of 2014 already hold that all fraud is arbitrable, whereas domestic commercial arbitrations have this dual classification courtesy Ayyasami and Rashid Raza now, that some frauds are arbitrable, such as simple fraud, but complex fraud is not arbitrable. So parties, when they feel that there is a complex commercial contract of high quantum, they will not want to get involved in this dispute, whether it's simple fraud or complex fraud. So they can just simply move the arbitration abroad by having a clause in their arbitration contract or in their agreement in question by saying that these disputes will be seated outside of India, because as soon as it is international commercial arbitration, all fraud is arbitrable. So that is one particular feature. Now the second, or another important point which comes about in this is that courts, by holding that you should not adjudicate disputes at the pre-reference stage, have already done so in Bogara Polyfabs in 2009. In Bogara Polyfabs, the Supreme Court already said that courts should not adjudicate on arbitrability at reference stage, and that is the domain and that is the preserve of the arbitral tribunal to do so, wherein through section 16, through the competence principle, it can hold and it can decide what disputes are arbitrable, what disputes are not arbitrable. And the last problem is that the Supreme Court, through this dual classification test of Ayyasami, subsequently affirmed by Justice Nariman in the Henry Schein case, in the Rashid Raza case, is that it moves away from global best practices. Global best practices are that whatever be the dispute about the arbitrability, in keeping with the competence principle, it should be the arbitrator who decides on those issues. Now, these are global best practices which have emerged, and the US Supreme Court recently in 2009, via unanimous decision authored by Justice Brett Kavanaugh, said that even if somebody were to believe that a reference to arbitration is wholly groundless, it is not the judicial forums which will decide, or it is not the regular courts which will decide as to whether this dispute should be referred to arbitration or not. It will be the arbitrator themselves which decide. So even a case which is a reference which could be wholly groundless as a reference to arbitration will be decided by the arbitrator themselves and not by regular judicial forums. So this this is something which the Indian courts need to align themselves with, as opposed to creating this duality and this dual classification of simple fraud and complex fraud. Which is why the 246th Law Commission recommendation was extremely progressive in nature, wherein it said that please make all frauds to be mandatorily arbitrable. As soon as you have all frauds mandatorily arbitrable, you align yourself with best global practices. So in what happened in the US Supreme Court in 2019 could have been the Indian position much prior in time if we had only implemented the 246 Law Commission report's recommendation in this regard. So in this particular case, the decision of the US Supreme Court in Henry Schein of 2019 could very well be in the Indian position had we only opted to implement the 246 Law Commission report recommendations vis-a-vis Section 16. So with that, we come to a close of the lecture part